Good evening to everybody. We are going to commence in less than 2 minutes. Please stay with us. Thank you. Good evening, ladies and gentlemen. Thank you very much for joining us today at ICC webinar on managing cost and construction disputes. My name is Habib Rizwan. The webinar will be for 1.5 hours. I would like to mention that the webinar will be video recorded, which can be used in the future for any educational or promotional purpose in the future by ICC. If you have any comments, you can post them in chat box. And if you are asking any question, you can ask it in the Q&A section below. Thank you very much. I will hand over to Sami Hawarbi, who is the Director of ICC International Court of Arbitration for the MENA region. Over to you, Sami.
Thank you, Habib. Hello, everyone, and welcome to you for the today ICC. If you allow me, I would like first to congratulate our partners, ADGM and ICC UAE for their success during these challenging times, despite the economic slumps caused by the pandemic. In particular, I would like to congratulate ICC UAE for standing out with ICC Australia as the only two national committees to have shown to be the most active and profitable ICC institution. You may have noted that ICC was early on very responsive and succeeded to adapt to the crisis and responded to the needs of its users. And most of ICC projects in the pipeline were pursued and finalized. Allow me to share with you some updates in this regard within 1 minute. On virtual hearing, a lot has been so far said, and you have noted that everything in the ICC note related to the COVID. We have launched our new internal case management platform based on SAP technology, replacing old ICA base. And this will allow to open SharePoint with their documents in a secured environment. In addition, we have launched arbitrators, council, and the sector of industry. We are now notifying electronically all correspondence by email or through a link for secured space when the documents are voluminous. Despite the crisis, we have continued to work on our projects to strengthen our presence in the region, and we hope to announce it with our partner ADGM by the end of this year. During this period, the ICC Arbitration Commission succeeded to amend its rules, and the new version will come into force on the 1st of January 2021. The new rules will be presented during the Dubai Arbitration Week, again, with the support of ICC UAE. Finally, with the support of ICC UAE and its Arbitration Commission, we were able to launch the new ICC publication, A Guide to Arbitration in the UAE. And we are proud to count the authors of this publication, Hassan Arab, Mahmoud Hussein, Gordon Blank, Alain Farad, Philippe Pounvar, as the members of ICC UAE Arbitration Commission. This most updated guide to arbitration in the UAE will be presented again during the Dubai Arbitration Week. I would like to say the opportunity to emphasize the great job done by the ICC UAE Arbitration Commission under the chairmanship of Hassan Arab. Last and not least, and back to the subject of our today meeting, we launched with ICC UAE a series of industry sectoral webinars. We had the first webinar a couple of weeks back on IT disputes, and today we are holding the second one on construction. But before starting the debate, I would like to give the floor to Hassan Arab, the president of ICC UAE Arbitration Commission. Hassan.
Thank you so much, Sami. Well, good evening, ladies and gentlemen, and welcome to this webinar. Under my capacity as a chair of the ICC UAE, I would like to welcome you to this webinar. And before we start, actually, Sami talked about most of the initiatives, so he make it very easy for me But to those who are not aware about the ICC UAE, ICC UAE, if it's correct to say it, it's a voice of the ICC in UAE to promote the international arbitration in general and ICC arbitration in particular. The steering committee and the arbitration commission is quite active, as mentioned by Sami. We are working closely with ICC Paris, with the commission there. And one of the main objectives for the commission in UAE is to support the commission in Paris. And recently, members of the ICC UAE, they participated on the task force with regards to the amendment of the ICC rules. The other initiative was the publication of the guide to arbitration in UAE, which Sami mentioned just now, and it will be launched during the arbitration week. The commission, actually, it's a combination of members of local and international practitioners. We have the aim to promote the arbitration, and as I said, and to encourage the practitioners, especially the local practitioners in UAE, to be quite active and positive members of the international community. Today's webinar dealing with an interesting topic. It's a very important topic, especially in this region. As you know, the construction sector is quite active sector, and during the COVID or this crisis, we in dispute resolution, whether it is litigation or arbitration, believe that lots of disputes will arise. Already started, actually, the signs are there. Therefore, we thought that this webinar and the topic will deal with the quite important topic. And without taking much of your time, I will leave it for Alan and his distinguished panel to present this topic. Alan, the floor is yours, and thank you so much.
Thank you very much, Dr. Hassan. I'm delighted to moderate this distinguished panel today, which, as Dr. Hassan mentioned a moment ago, will address the complicated topic of the management of costs in construction disputes. Now, this is a particularly sensitive topic in the times of COVID, where many contractors are facing financial difficulties and indeed the risk of insolvency. I'm sure many of you have heard of the news of a possible future liquidation of Arab Tech, a major contractor in the region. And so against this background, and a background of, as Dr. Hassan just mentioned, proliferation of claims, which we already start seeing, the ICC and the ICC UAE Commission on Arbitration and ADR thought that it would be beneficial to the arbitration community and also the construction community and all those who obviously intersect both communities, to hear advice from leading professionals in the field of construction disputes on the specific question of the management of costs in construction disputes. So today, we will cover three subtopics within this general topic. The first one is what parties to construction projects can do to avoid disputes or limit their costs. We will then talk about a particular topic which is dear to the heart of the ICC, because the ICC has specific rules about them, which is the use of dispute boards to limit or resolve existing disputes in a cost-efficient manner. And finally, when disputes are unavoidable and you have to go to arbitration or litigation, we will talk about the availability of third-party funding of claims, for instance, when a party has worthy claims but has no funds to bring them. So to address these topics, I will be accompanied by four distinguished panelists today in alphabetical order of their family names. I'm sure you know them all, but allow me to introduce Alex Bevan, partner at Sherman Sterling in Abu Dhabi and a member of the ICC UAE Arbitration Commission Steering Committee. Joe Durkin, who's an investment manager at LCM Finance, a third-party funder. Lara Hamoud, who's an independent international arbitrator and a senior legal counsel in charge of disputes at ADNOC. And finally, last but not least, Lindy Patterson QC of 39 Essex Chambers, a barrister joining us today from London. A word of thanks to the ICC Court in Paris and the ICC UAE for making this event possible. And before we start, a word of disclaimer from me to say that our panelists today will be speaking in their own names, not in the names of their respective organizations, and that what they are going to tell us today reflects their own views and not necessarily the views of their organizations. So without further ado, let's start with our first topic. And the question I'm going to ask, and I'm going to start with Alex Bevan, regarding what parties can do to avoid and limit the cost of construction disputes as a construction project unfolds. In other terms, early management of claims to avoid disputes or limit their costs. Alex, what's your point of view? What could employers and contractors do to avoid or manage disputes as their projects unfold?
Thank you, Alain. So just by way of a preliminary comment, I suppose, to that question, I think Dr. Hassan said the construction sector is very active. I think it's unusual. We have to recognize that it's an unusual industry in just how contentious it is, just how many matters escalate to a dispute rather than be settled on project. And also it's unusual in the sense that when construction claims go to arbitration, they tend to be too expensive. Too many construction arbitrations are too bloated. I think there are a lot of reasons for that. Partly it's the subject matter. They're very heavily fact dependent, very technical, but also partly the parties. And it's rarely one party that's responsible for that. I think both parties have a role to play. So if we think about on project, starting with employers to start with, think about on project, what they can do. One feature or tendency, particularly in this region, is, although it's not exclusive to this region, is the tendency for an employer to put its head in the sand when faced with issues raised by the contractor on the project, to try and ignore issues, to try and bat things back. The reality is they don't go away. They need to be dealt with as and when they arise, which means recognize there's an issue, assess it proactively, get experts involved if need be, technical experts, get lawyers if need be to advise on the employer's position. Then once they have a proper assessment, because they've been proactive in assessing it, then you move on to actually doing something about it. And that means give relief to the contractor when it's due. So if it's a variation, recognize it's a variation. If it's a change in law, recognize that. If it's an impediment of the contractor's works, recognize it as such. The mantra that's being used typically of no time, no money to the contractor simply doesn't work. Issues that arise on the project are never 100% the contractor's fault, rarely rather. And so failing to give any recognition for even obvious entitlements has a counterproductive effect, because what it does is it causes a contractor to become entrenched, to become very claims focused, to start thinking about recovering its P&L on that particular project rather than delivering the project. And it's counterproductive for an employer. If in spite of assessing the claims and giving relief when due for those things that are legitimate, an employer is unsuccessful in managing the dispute and it still bubbles up to arbitration or litigation, then for the employer, all too often what I see is employers taking too hard a line in an arbitration, by which I mean putting the contractor to strict proof of factual matters on the project, which really shouldn't be disputed. And what that leads to is more disputed matters, both parties incurring more costs in the arbitration, and ultimately, in many cases, the employer having to pay the contractor's costs at the end of the arbitration if it's taken too unreasonable a position and tribunal's gone against it. So that's a quick snapshot of what an employer can do. On the contractor side, when an event happens on a project and they think they might have a claim, the key is to get advice early. And whether that, I'm not necessarily saying it has to be external legal advice, it can be internal legal advice. The problem all too often is that claims are worked up by the in-house project, so by the project team, and sometimes false expectations are set within the contractor about the viability of those claims and their merits. And it's important to set expectations realistic, expectations within the contractor early on. Once a contractor has formed a realistic assessment of its position, the key then, and you'll see these are sort of counterpoints to what I say about the employer, the key then to manage costs is to not overreach in what you're asking for as a contractor. Some contractors, as we all know, get a bad name for claiming everything, and employers know this. And this causes employers to push back. So it's understandable that contractors might build in something of a margin in presenting a claim. But if what is claimed is not reasonable on its face and defensible in practice, the danger is they get much less than they expect, in fact, nothing. And you get an entrenchment of positions, you get an escalation of disputes. Then if the matter escalates, what can a contractor do, or it looks like it's escalating, what can a contractor do to manage the potential costs of an arbitration down the line? Well, one is, all too often, contractors mount disruption cases or delay cases premised on things that have happened on the project for which they don't have an adequate documentary record. So whether it's getting your workforce to fill in timesheets with cost codes, whether it's making sure your daily reports are accurate and the project's control teams are accurate in what they're putting out, it's a lot cheaper to mount a delay case or a disruption case on the basis of a full set of comprehensive, accurate, factual records than it is to hire an expert after the event retrospectively to try and reconstruct the project record to mount a delay or disruption case. Because that's where the cost is. That's where a lot of the money goes in an arbitration. Over to you, Alan.
Thank you very much, Alex. So, yes, so early management, proactive management, and also managing the expectations internally. I would be curious to know if, Lara, you agree with this point of view, and what are generally your experience and feedback on what can be done by parties to construction projects to manage or avoid disputes.
Yes, thank you, Anna. I very much agree with what Alex just said, and I do believe that that's in my experience, both as arbitrator and in-house, that many disputes could be avoided at the front end phase if things would have been done differently. In many circumstances, the disputes arise because of unbalanced risk allocation, because of the dynamic that that the parties had started with. And I'm going to just give a few examples of issues that would very often arise or give rise to disputes at the later stage, subsequently in the project. One of them is that I believe that there should be an equal allocation of risk between the parties. I believe that the risk should be allocated to the party that it is in the position to control them. And you can see it and anticipate it. So we were talking, as Alex was saying, that what can employer do, what can a contractor do? So in preparing, for example, the contract document bid package, the employer will be in a position to decide, on the risk allocation. So the employer may be tempted to allocate all or most of the risk to the contractor. But I believe that an employer must be tempered, or this temptation must be tempered by an understanding of the potentially adverse consequences of allocating the risk. So that's something to keep in mind. I would also give another example without going into too much technicalities, but there are things to take into account that can, when they are considered or well done, would definitely avoid disputes. And one thing is the feed, and especially the incomplete and the deficient front-end engineering design. And I've seen many disputes that arose because of this issue, because either the employer wants to rush and start the project, or the feed was not just, contained a lot of deficiency, and employer would ask the contractor to endorse the feed. And here we go. Subsequently, we have problems that arise due to that deficiency and incompleteness, and obviously the contractor would want to be compensated or find a way to be compensated for this. Another example is to avoid also some disputes is all the issues around the rely upon information. And here again, at the very outset of the project, we have an issue because the issue is that the contractors, they want everything to be rely upon information, and the employer wants nothing. So here again, you have to, I think both parties need to, with a view to avoiding dispute, need to address those issues with, finding a balance between, the risk allocations for the project. One thing I would say about, limiting costs of disputes. I mean, if during the project there's a dispute, or claim, then that's it. Let it be. But I believe it's a two-way street. The contractors need to be responsible for submitting documented and justified claims if you want to, limit the cost. And the employers, and that's what Alice was saying, they need to be in a position to respond to claims promptly and settle where justified. If the employer believes that the contractor has a point for their variation, then let's pay the variation. I am in favor of an early assessment of the claim, as Alex was saying, and for addressing the claims promptly. I believe that legal assessment should be done at the earliest possible to set the expectations of both parties and to try to find the best, mechanism to settle, the claim or to find, the best way to manage the dispute and the costs. I would stop here for the moment, Alain.
Thank you, Lara. Many of the points you made resonate with me. And in particular, the question of the contractual balance. It's true, I mean, we're all dispute resolution lawyers here on this panel, but what I have observed over the years is that good contracts are balanced contracts, and contracts that lead to disputes are generally significantly or unbalanced in some way. And so perhaps Alex, as a private practice lawyer, what do you think should be our roles as external counsel in addressing these issues early, helping clients address claims or risks of claims early? And going back to Lara's point, what input can we provide in ensuring that contracts are balanced?
So you might think, okay, well, let's deal with the first part of your question first, which is on project, what role can outside counsel have? You might think, and a contractor might think, for example, or an employer might think that bringing on outside counsel is going to lead to increased costs immediately. It might do. But there is a point here about, if done properly, examining your claims properly, you have cost savings, right? So it's important not to be penny wise and pound foolish. And so if you take, for example, a contractor has a claim and the project team has worked it up, and it has parts of it have merit and part don't, but there's, say, for example, a fatal note, or there's a pivotal question about the validity of the notice that was given, which might impact the validity of the claim in its entirety. That's a relatively quick, relatively easy, self-contained, limited scope question that a lawyer needs to look at. It can be internal, it can be external, and often it'll be external. It doesn't cost a lot of money, but what it does is it could save a lot of money, right? And so that's a little bit of the role that outside counsel can have, but there's responsibility that comes with that. And I think it's very important that if external counsel are brought in on project, that they don't add fuel to the fire. I think this is a professional ethics point, that if a client wants to de-escalate a claim particularly on the employer side, wants to manage and contain it, that the advice should be, the strategic advice, the legal advice should be aimed at achieving that goal, which is non-escalation. Otherwise, a bad lawyer can lead to the escalation of the claim, which nobody wants. I think just on the point, your second part of your question, which is about the contracts, I mean, what Lara says about balance of risk in a contract is very important. How many disputes do we see that concern design responsibility? So whether it's errors in the design, completeness, design development responsibilities of the contractor versus changes. Clarity in the base design is essential. Clarity as to who's responsible for what under the contract is essential. And as you both say, a realistic and reasonable balance between the parties is essential. So as disputes lawyers, what we can do to our colleagues who are negotiating the EPC in the first place is actually explain how things are going to play out if the risk allocation is too one-sided. Because we can say, well, look, this is how it ends up at the back end, which I think is a very valuable way of containing disputes.
And it takes some strong lawyers and healthy conversations between external and internal lawyers and the projects teams to be able to have that conversation and to convince the people in charge of project that pushing too much on a contract can have significant cost at the back end.
And it's counterintuitive. It's counterintuitive, right? So the classic one is we want the contractor to have to notify its claim within 3 days or otherwise it doesn't have a claim. Well, is that realistic? Because if it's not realistic, it's not going to stop the contractor raising claims. In fact, what he's going to do is challenge that notice provision. So why not give him 2 weeks or 21 days? Because that's going to be much more of a safety valve, a pressure release valve.
One thing, sorry, I don't know if I can interject without having your permission, Anna. But just wanted to also say to add on this is that we need to be careful when we push too much on either side, because there are tactics that are played at some point, and that's what when I was talking about the dynamic. There's a tender, there's a bid package, the contract is not balanced. What would a contractor do? Either add contingency on the price, or if it wants to be competitive, it would not. But then throughout the project, I would say that it's highly likely that the contractor would find ways to get compensated for that unbalanced risk. So that's also something that the employer needs to take into account. And many often there are inflated claims that we see.
It's very true, Lara. One more point comes to mind with respect to the balance and lack of a balance in the management of these projects, which can be costly at the end. And it's the role of the engineer. Would either of you care to say a few words about, or if you have any thoughts on what can be done to improve the role of the engineer so that the engineer can really serve a purpose in avoiding disputes, rather than sometimes, as we see on projects, creating the circumstances of a dispute? Do you have anything to say about that, Alex?
Yes, I mean, it's a good question, because it's something that emerges a lot where you have the engineer with a formal role under the contract or any other contract administrator that has, at least in part, an independent role. And the issues arise where the employer considers the engineer to be his agent and applies pressure on the engineer to make sure the determinations are in favor of the employer, that the decisions are, that recognize that the assessment of claims is employer friendly. The overall, the undue influence on the contract administrator by the employer is something that unravels. It comes out in arbitrations, right? And it's often looked very poorly on by tribunals. It's an odd one because engineers have two hats under FIDIC, right? They have the contract administrator role, and in some respects, they are truly the employer's agent. But where they are administering the contract independently, they must do so. And employers rarely get away with in the end, with exerting too much influence.
That's correct. And so do you think anything should be done to improve the status or the independence of engineers so as to avoid costs in contracts? Alex, I don't know if you want to answer. Lindy, I see also you may have something to add.
Yes, I mean, I guess the difficulty with the engineer is that the employer is paying him. So as we know, as Alex has said, the engineer is wearing two hats. So the engineer is continually, I guess, in a difficult position there. The contract, I think, tries to identify that an engineer should act independently when making determinations, but I think there's this continual tension between the fact that he or she is being employed by one of the parties.
Correct. I think this is an area for further exploration and for the improvement if we want to push in favor of more efficient project management and dispute avoidance and resolution. But let's move on for now. And there's another topic which we wanted to address today, which is the question of dispute boards. And so I wanted to ask Lindy, what is, in your view, the role of dispute boards in the topic we're talking about, avoiding costs, reducing costs, narrowing down disputes?
Thank you, Alan. Just before dealing with that, it might be useful just to give a brief description of dispute boards. I'm sure most of the audience are familiar with them, but it's worth just remembering, I think, where they come from, because dispute boards are a creature of contract in the same way that really arbitration is. But the difference with dispute boards is that apart from maybe a couple of countries, dispute boards are not underpinned by legislation in any form, unlike arbitration. We have arbitration acts in many countries. But dispute boards are found in the multi-tier dispute resolution clause, typically in a construction contract. But their role can go well beyond dispute resolution in its formal sense. And that, I think, is where what Lara and Alex has been talking about really plays into the role of a dispute board. And the reason for that is that in many contracts that contain dispute boards, they're appointed at the beginning of the contract, so before any disputes have arisen. And the aim in those situations is for a dispute board, which can incidentally be one party or three typically, to gain a general understanding of what's happening on the project as it proceeds, with the aim of trying to avoid disputes, trying to identify issues before they become formalized and before parties become entrenched. The way that it typically happens in my experience is through the meetings which take place with what we would call a standing dispute board. That is one appointed at the beginning of the contract, because the contract provision will state that parties will meet quarterly with the dispute board. And it's very interesting at these meetings that both parties bring to it often different things to that they might bring to site meetings. They perhaps behave better towards one another. They will perhaps disclose issues that are concerning them that they may not have done in standard meetings. And I've had this a number of times where things are maybe getting difficult on a job. Directors attend one of these dispute board meetings and information is exchanged, which had not been exchanged for months. And that can assist so much. As a dispute board, you will identify if there's a shortfall between what the contractor is applying for and what has been paid. That may be a flag to identify that there are going to be issues down the line, or if the project is starting to run late and parties are not in agreement as to why that is. So these are all issues that can be explored by a dispute board before you get to the formal dispute process. If, however, a dispute does arise, many dispute boards are charged in the contract as being the first port of call for issuing a determination on that dispute. It's not always a determination or adjudication. Some of them are recommendations. So you will have a DRB, which is a dispute review board, which will make recommendations as to how an issue should be dealt with, and others where the dispute board will issue a decision or an adjudication. And parties are obliged to comply with that pending any ultimate resolution by arbitration or court, depending on what the dispute resolution process states. So in the main, the dispute avoidance rule for dispute boards, I think, is where the focus is going forward. There's been a big push, for example, the FIDIC standard form contract now specifically refers to dispute avoidance. The ICC dispute board rules provide for a variety of different types of dispute boards, but for example, it provides that the board may identify and deal with disagreements and what I would describe as informal assistance to parties. So these are all aspects of dispute boards which, to my mind, if they're operated properly, can save quite significant sums of money. It's also worth noting that the ICC has model clauses that one can put into your contract regarding dispute boards, and there is a selection of different types and forms of dispute boards that you can deal with. Thank you.
Lindy, thank you very much. It's very interesting. You've highlighted the informal aspects of dispute boards. Now, I have to tell you, I did one dispute board case a few years ago in a large infrastructure matter, and which ultimately led to an arbitration. But the dispute board process looked very much like an arbitration. It was an arbitration without the name of arbitration, and the clients considered that it was overly procedural and expensive. What do you have to say about that?
Yeah, I mean, this is a challenge. Typically, the dispute board provision will provide that a decision is reached within, say, 80 days or something like that. And certainly the dispute boards that I've sat on, we will almost always aim to deal with it within that period. And if I might be so bold, lawyers have become involved in some of these processes. So, of course, the default for many lawyers is to adopt a pleadings approach to the referral of a dispute. Now, I am certainly not against lawyers being involved, but I think it does take a bit, in the way that Alex has described, a different approach to that you might deal with in arbitration. But that is the challenge, and I think it's down to the dispute board to try to deal with that, because you're absolutely correct. You do not want to have a rerun of the full arbitration process. It really defeats the purpose of the dispute board.
So you put your finger on the culprit, Lindy.
Not completely.
let me directly ask one of the culprits, and I'll join you, Alex, in that team. What do you think we can do as external lawyers to try to make that process perhaps more efficient and perhaps less like a copy of arbitration proceedings?
Yeah, I mean, I think Lindy's put it much more elegantly than I would. I genuinely believe that the over-lawyerification of the dispute board process is its real downfall. As you say, Alain, it's not an arbitration, and it shouldn't be approached as one. It is rough justice, right? That's the idea of this. It's an 80-20 type analysis. It's meant to be cheap. It's meant to be quick. It's meant to be imperfect, but that's fine. If it's a review rather than a decision, it gives the parties a reality check on their positions, brings them closer to allow a settlement to be facilitated, which often happens. If it's a decision, yes, it might be a rough justice type decision, but that's the value that it brings. And when you over lawyerify it and you start having, and I think actually, to be fair to us, Alain, part of this is it depends on the composition of the board itself. Lawyers sitting as experts on DABs and other type of boards can recognize it for what it is, or can sometimes themselves get bogged down in procedure, in due process, and in all the sort of, and allowing an adversarial culture to develop within the board or within the procedure, which are all the problems that afflict arbitration. So I think the roles are on the members of the board itself, but then also on counsel to approach it not in the adversarial way you would in arbitration, not in the forensic way you would in an arbitration, no stone unturned, but in recognizing it for what it is. Its speed and its cost efficiency is its value, even if it's imperfect. But it's important not to throw out the good at the expense of a quest for perfection.
I like the term you used, rough justice, and it's true that part of the problem is that those involved in the process are the same arbitration lawyers who then do the arbitration, and therefore they do what they know, which is arbitration, and so they replicate it, and they often try to pursue perfect justice, which is difficult to achieve, and certainly makes the process more complicated than it should be. But Alex also mentioned recommendations, decisions. Let me turn back to Lindy. What is the point of these decisions or recommendations if they are not enforceable? And are they not enforceable? And if they're not, what are we doing? Are we not wasting time?
Well, enforceability of dispute board decisions varies across jurisdictions. There are many countries, particularly those that have what we would call an internal domestic adjudication law, and are used to this concept of enforcing temporarily binding awards. But there are other jurisdictions where the courts are uncomfortable with enforcing what they see is not a final decision. I think for anyone who is interested in this subject, the judgments in the Singapore case of Persero, which many people will have heard of on this webinar, are very informative, because that was a real saga of parties refusing to recognise dispute board decisions, and ultimately the judges determined that there was a finality to a dispute board decision, albeit at a later date the situation might change. And I guess this goes back to the point, which is that if parties buy into a dispute board process and see that it's to help the project, and that's a very important point, I think, as a dispute board chair, which is what I do say right at the outset, that this is about assisting the project to reach completion, etc. If parties buy into that, they may well be comfortable with abiding, even if it's temporarily, with, for example, a recommendation. In the States, for example, where dispute boards are prevalent, they are all recommendations. None of them are decisions, but parties have a culture of accepting them at that point. And it's interesting, I was on a webinar last week with people from the States about this, and one of the lawyers said, we use these recommendations as a base for negotiation at the ultimate final account stage. So I think it's easy, I think, for people to say, well, they're not going to be enforceable in my region or my jurisdiction, so what's the point? But I think it probably ignores the wider issue of bringing the project to completion and trying to facilitate a way for doing that.
Thanks, Lindy. So what I've seen on a project is that while the decision was not enforceable, it was used as evidence in the subsequent. First of all, it did narrow down somewhat the dispute, making it therefore more efficient in the arbitration stage. But it was also used as evidence by the party who was the beneficiary of that decision to try to convince the tribunal. Then the tribunal is, in most places, is free to give it the weight it wishes to give it, but it was used as evidence, so it was not entirely unused in subsequent stages. Lara, do you have any feedback on the dispute board process with your experience?
I'm going to be very candid here. I in principle very much believe that the dispute boards can be, very helpful and efficient. And I've heard a lot of very positive outcomes in projects. But I have to say that in the region, in my experience here, I haven't heard or seen dispute board really emerging or being really popular. And I wonder why, because if you look at, the features of dispute board, one in principle would say, well, this is amazing. But I don't think that it's having the popularity that one would expect. And I think it's very much cultural. And Lindy just said something that kind of like, triggered something in my mind. It's the culture, the American culture accepting, the recommendation. I think there are nuances in the UAE culture, and I say the UAE because that's the one I'm more familiar with in the region, where I'm not sure the parties themselves would want, in the middle of the project, to have an assessment or a recommendation or a decision, because that would relinquish their control over the dynamic or their control over the project. Or I think, I believe that the culture here is not as, I would say, cooperative, or not. That's the right word. But in terms of complying with the recommendation, I'm not sure to what extent a party would want to put itself in that situation. I think what parties here would prefer is to wait until the project is completed and then here we go. Let's try, which is not a good thing. And so that's something that I'm trying to understand. Maybe that's why it's not really getting very popular with some parties here. The other thing is sometimes I feel that it's not very clear yet. People are not completely familiar with it yet. It is complicated. It's supposed to be straightforward, but actually it is a complex procedure. You've got the review, the recommendation, the decision, the standing, and starting also from the beginning, convincing a party to already appoint someone who would resolve or decide or assess or recommend on a future dispute. It's also sometimes, whoa, we won't have a dispute. We won't have a claim. We won't have disputes in this project. So why would we? So I'm just trying to find the reasons why I believe in the region, maybe I haven't seen it kind of like emerging, if that makes sense to you.
Thank you, Laura. Did you have any reaction to that, and in particular the cultural aspect, which Lara mentioned? It's true. I mean, North Americans or some other cultures, cooperative. Here we have more difficulties with that. Do you have any tips for this region
Yeah, I mean, there are dispute boards in the region. I mean, I'm aware of about 4 that are running at the moment. But I agree, it's not prevalent. And the comment that is typically given to me is, well, it's unenforceable, so what's the point? And I think that...
you know where my question came from.
Yes. But I think it misunderstands the benefits that one could get from a dispute board. And just picking up on Lara's point, which was, well, why would people interrupt what was happening on the project to almost be diverted by a dispute board referral? I'll give us a very common example, the standoff between a contractor and employer, where the contractor says, I need an instruction because this is a variation, and unless I get the instruction, I'm not doing this work. And the employer saying, I'm not giving you the instruction because it's within the original scope of your works. Now that can present a huge problem with progress. It's a complete standoff, which may actually run the project and the timescale into the sand. And that is the sort of thing where a dispute board, in my view, can intervene. It can be on a temporary basis or whatever, but a dispute board can give parties the comfort and protection almost to allow, for example, these works to continue without parties maintaining the entrenched position. And they can, you might say, live to fight another day, but it just gets over some of these barriers where people are sort of sitting in trenches at a time when they should actually be progressing the project. So it's these sort of things, shortfalls in certification, major issues about that. These are the sort of cash flow issues that are often referred to dispute boards. But I agree, there are some regions where it's more common than others. For example, the multilateral banks, World Bank, Asian Development Bank, etc., very often insist in projects that they're funding that dispute boards are written into them because they feel comfortable with the concept and they believe it protects their investment. So that in those situations, dispute boards are almost imposed on the parties. So that there are lots of nuances as to their use. I mean, I would like to think that the region is just a bit of a slow burner as far as the use of dispute boards are concerned, but it does involve an understanding from both parties and the engineer and an acceptance that these will actually help the project.
Thanks, Lindy. I mean, this is a very interesting topic, and I encourage those who are listening to us to, if they're interested in dispute boards, to go on the ICC's website and look at the latest version of the ICC dispute board rules, which you can find on the ICC's website. And that allows me to progress on the topics that we have decided to cover in this panel. And moving forward in the dispute process, a dispute has arisen, and we are left with the question of funding that dispute. Many parties may have adequate funds set aside for funding their lawyers, experts, and arbitrators, and whatever costs arise normally from the dispute resolution process. But some parties require funding. And so we are fortunate today to have with us a third-party funder, who I should say was previously a lawyer, and he will have to explain to us why he decided to join the dark side. Perhaps that could be part of your answer to my first question. But can you give us a primer for those of us who don't know much about third-party funding, a primer on what is third-party funding and what role it can play in addressing the issue of costs in the management of disputes, construction disputes?
Very much, Alain, for the introduction. I think the director's cut might have a little bit more on moving over to the dark side for those who hang out to the end. But in its most basic form, third-party funding is really simple. It's the provision of capital from an external source to pay the legal fees, usually of a claimant in a dispute, whether it's arbitration or litigation. Clearly in the Middle East, we tend to see it more in the context of arbitration, but there are some cases being funded in the local courts, which is litigation, obviously. In short, the funder will agree to bear all of the claimant's legal costs, which includes solicitors' fees, barristers' fees. You've got independent experts, claims consultants, costs of the court, arbitration costs, advances, and so forth. The funder will also provide, where it's needed, a secured indemnity to cover any adverse cost, awards, or exposure in that regard. So in return for this, the funder will receive its money back in a pre-agreed return on its investment. The funder's return is usually, these days, determined by a multiple of the actual invested capital, but it can be, as it was in the old days, a percentage, a fixed percentage of the proceeds, which is the most simple explanation of, let's say, the fee element to it. It's important to note that litigation finance does not give the funder any recourse to the claimant's assets. So it's totally non-recourse. The funder's capital is lost if there isn't a successful outcome, and a successful outcome is where you ultimately recover money from the opponent. So the funder only recovers in that regard. The market grew up in Australia in the late 1990s, came to the UK post global financial crisis in around 2008, 2009, 2010 onwards, and it's found its way to the Middle East slowly, but it has become something that has taken off in the last 2 years, primarily to do with the construction industry. And part of that is to do with the fact that if you just look at the number of cases that are in the arbitral institutions, over 50% of them, at least regionally, tend to be construction or real estate. And there's other reasons in terms of why construction is quite suited towards it. Originally, we were talking more about funding out of necessity. If we go back to the early 2000s or late 2000s even, where without a funder's capital, a client actually can't take on a case. It's moved on since then, and funding can mean anything to whoever you speak about it. A lot of people have different experiences in relation to it. But in short, what you've got is very different products depending on the market that you're dealing with. You've got single cases. You've got, for example, monetizations, where you're advancing money against a pending claim. It could be an arbitration award that is granted, has to be ratified and enforced. You could be dealing with a portfolio of claims, for example, in the construction industry, where we see quite a lot of that coming out of the Middle East. You could be talking about an advance across non-performing loans, if you're dealing with financial institutions or banks. Or you could even be talking about making advances to law firms to take on contingent claims, which would allow them ultimately to draw cash as those cases come in. Or it could be any combination of those things. So the perception of single case funding, that you will fund a client who's impecunious and actually requires the funds for that reason, is what it originally was, but it has certainly moved on since then. In terms of, let's say, construction specifically, it lends itself very well to the construction market because of the peculiarities of the construction industry. As we know, construction is project-based, it's high volume, it's low margin, the legal spend has a big impact on profits, and there are usually multiple disputes because it's part and parcel of what the actual DNA of the construction industry is, which is revealed in the figures of, let's say, the leading arbitral institutions and the actual disposition to construction cases. So that's just a snapshot introduction.
Thanks, Joe. It's very helpful. For taking a step back, let's say one of our attendees wants to arrange funding. What are the steps? What do you have to go through for that funding to be arranged?
Yeah, so most leading funders operate in broadly the same way. The majority of our applications actually come from law firms. Sometimes they come from the claims directly, other times they'll come from barristers' chambers, their clerks or counsel. But typically speaking, we're talking about applications from firms. And what we ask for is a short summary of what the actual dispute is about. So if it's coming from a barrister or a law firm, that's quite useful because there will be a great deal of thought put into it. We're going to look for the salient documents, perhaps pre-action correspondence. That can be helpful, at least in seeing what the opponent's position is on the claimant's case. And then an opinion on merits and likely quantum is typically something that we would seek in a construction-related dispute. And more often than not, when we have all of those documents, we say, this is very exciting stuff. Hopefully it's a very good case, but we need to deal with the most obvious question, which is, how are we actually going to collect on this? Does the opponent have money? And is this case, as notorious as it may seem, is it one that is worth taking? So it's all about the collection risk at the end of the day. An award or a Pyrrhic victory means nothing to a funder, as it means nothing to a client as well. So we're looking at recovery prospects very much.
So do you hire asset tracers to find out what the prospective respondent has available, where and where that could be enforceable?
Yeah, typically speaking, that's part of the process, that you will have asset tracers involved. It'll depend on the jurisdiction that you're in. If you're in somewhere like the UK, you do have available to your company's house, there's certain information that may be publicly available. In other jurisdictions, that's a little bit more difficult. You could be dealing with...
difficult in this region, in the MENA region, where you are based.
Yeah, in the MENA region, it can be quite difficult. If you're dealing with a main contractor, Google Maps may show you where cranes are, but you may take a view that they're on hire in the first place. So really what you're talking about then is maybe accounts receivables, what projects that contractor is actually working on. And that's the type of market intel that you get pretty much on the ground from the likes of asset tracers. It isn't very scientific, given the issues in the region.
And what do you do with the question of SPVs, special purpose vehicles, that are sometimes the respondents in your cases? and that may have no assets or limited assets.
Yeah, well, we take serious concern with that. I mean, if it's an SPV and if it doesn't have any assets, if you're dealing with a developer, for example, and it has sold off all of the units in a particular building, what you would hope, for example, is that maybe there's a hotel in the mixed project as well, that you can see some sort of a way forward to actually get your hands on some assets in the end, or perhaps some of those units are retained by the developer. So that's a kind of a process that you need to come to some sort of an end result in terms of where you ultimately going to be able to cash that from. If there's no cross collateral coming from any third party, which there probably isn't, that's the reason that you set up an SPV in the first place, you may have a difficulty and it may not be worth funding from our perspective.
Right. That's the way many people do business in this region. So
yeah, it's a difficulty. It's one of those things that obviously contractors speaking to lawyers at the outset would hopefully have taken some advice on that, and they would take it on board as a risk at the outset. But retrospectively, they may not have done so.
Right. Now let's look at it from the point of view of the claimant seeking funding. You mentioned something that was interesting, that originally was for the impecunious claimant, the party not having enough funds. But so is there any point for cash-rich organizations to look for funding? Do you have requests from such organizations?
The simple answer is yes. Okay, so there's a misperception in the market that the clients for litigation funding are those who fund out of necessity rather than choice, and that's pretty much what it was in the late 90s up to the mid 2000s for various reasons. But the market has evolved significantly since then. There's a more sophisticated corporate finance tool that pretty much has emerged. Large corporate clients, they understand that the using of external capital out of choice rather than necessity is something that pretty much helps them when it comes to their balance sheet. So for example, sophisticated corporates will use that out of choice. The reasons are that it gives the ability for them to focus on their core business with their cash. So if you're a telecoms company, you should be focusing on telecoms and spending your money on that, not on managing a legal budget. The other aspect of it is that it allows you to reduce your legal spend on a monthly basis. So every dollar, dirham, or pound that you spend on legal fees, as admirable as it is to spend it on lawyers, what you're effectively doing there is reducing your net profit, and it's having a direct effect on your P&L. By using litigation funding, you take it off the balance sheet, and that has a direct effect in terms of the actual share price, particularly if you're a listed company. So sophisticated corporates get that, and that's part of the reason that they will actually choose funding. Another thing about it is that CFOs tend to be quite enamored by funding rather than general counsels. And the reason for that is it gives a positive effect for budgeting and forecasting for various reasons. Ultimately, the CFA knows when the money's going to hit his account and he can spend it on legal fees rather than having to go back to the business and get it as the need arises.
Right. Another concern that parties often have is, so what if I choose or I go through third-party funding? Will I lose control over my case? So who picks the lawyers? Who picks the arbitrators in an arbitration? Who makes decisions on strategy? You, because you have your money at risk, or the claimant whose claim it is?
I mean, the short answer to that is the funder doesn't take any control whatsoever. It's passive capital, similar to going to the bank. What we do is at the outset look at strategy, because clearly we're not going to get behind claims which don't have a clear strategy and route to success, which is ultimately recovery. So when you look at strategy, you need to have that in place before you can even complete your due diligence process and get on board with a case. You need strategy to get an effective budget and to pretty much tell us what the investment is going to be so we can decide to go with it or not. So the other aspect of it is in terms of your question, who chooses the lawyers? What we expect is that the legal team is going to be excellent. They're going to be able to deliver the case, and ultimately they're going to be able to get a success. We don't choose the lawyers. The client chooses the lawyers at the outset if we are not happy with the legal team because we don't believe that they have the experience for that particular type of dispute. It could be a factor in terms of why we wouldn't actually proceed. But once the case is in place, we don't interfere with that. What tends to happen is we get monthly reporting. There's a budget which is set out, and we expect that the legal spend will match the budget in as so much as it can be, because these things obviously can change from time to time. So good funders won't impose any restrictions whatsoever on the legal team or on the client's strategy going forward.
Yeah, but I mean, you need to find comfort in your initial analysis that the legal strategy and the legal team implementing that strategy are going to lead to success. And so what happens if in the course of the dispute, there's disagreement between you and the client thinks the lawyers are excellent and you think actually they're doing a rubbish job. What do you do then? You're stuck with your investment.
Well, yeah, so what tends to happen is, so much as we can, we draft very comprehensive litigation funding agreements which will address and set out what we expect is going to happen. So, for example, a type of a disagreement could be over whether there's going to be a settlement or not, okay? And that could be something that the lawyers do or don't advise. All of these are predictable things that we can actually address on day one and decide what is going to happen if there's a disagreement in that regard. So we pretty much put it in the contract and we perform the contract as regards any of those particular points. What we quite often see as well, and many funders do this, they tend to work with a number of law firms that they're comfortable with those individuals, comfortable with their skill set. It still is a relationships industry. And it's not that we pick one or two firms. We will work with those who we believe are good and have the quality, and ultimately, that you may get on well with, and that you don't want to end up in a situation where for some reason you're going to end up in a dispute. So we cover that off as much as we can.
Thanks, Joe. It's very clear. Let me turn to Alex. In your point of view, Alex, is there any obstacle, whether legal or economic, for the development of third-party funding in the UAE? And I know that was actually a question we got from one of the attendees.
Well, in the UAE, there's no legislation which prohibits third-party funding, and that tends to be the case in many places. The laws that typically impeded the development of funding, the sort of ancient relics of common law jurisdictions like champerty maintenance, they don't exist in the same way in civil law. And so as a result, the legal impediments that used to exist in common law jurisdictions have never really existed here. And in fact, whilst there is no UAE law on third-party funding, there is a DIFC regulation and an ADGM regulation. So no legal obstacle. There are, though, cultural, quasi-cultural, quasi-economic obstacles. And as Joe said, that funding a claimant is not just for cash-strapped claimants, but what's unique about economies like this is the fact that they're state-dominated, particularly places like Abu Dhabi, right, or Doha, and state-owned companies. And I'd be interested in hearing Joe's point of view on this. State-owned companies, when I've spoken to them about funding, they tend not to be in the market for it because they don't tend to have the liquidity issues. And they don't tend to need to get the risk off their balance sheet in the same way. If they're respondents, on the other hand, again, funding claims against state respondents or state-owned respondents. In this part of the world, there are question marks about the enforceability of, the ability to execute against state-owned assets. And so recovery prospect, Joe said it's all about recovery prospects. I'd imagine that there's a kind of a structural impediment there to the funding of claimants against state-owned entities, because ultimately your route to recovery is a little trickier. In private-to-private disputes in the UAE, though, it should seem to me that funding is ripe for development, in the sense that we now have a federal arbitration law, which is a good arbitration law. There's been a very significant development of the arbitration network and framework in the UAE in the last decade or so, and there's no reason why it shouldn't flourish, or at least develop somewhat.
So let me ask this of Joe as well. In your practice as a third-party funder, do you see any obstacles because of the features of the economy in this country and in this region, the state-owned entities? They're both difficult. They're both not natural customers for your services, in the sense that you expect them to have funds, although we discussed earlier that you could also have well-funded customers coming to you. But they're also difficult because they're often on the opposite side of cases, maybe often on the opposite side of cases from you. and there are difficulties, specific difficulties with respect to enforcement against state-owned entities. What do you say about that?
Yeah, so our view is that we look at every opportunity pretty much in the same way. The due diligence requires us to see that there is a route to recovery. So if, for example, you're dealing with a particular state-owned entity, and perhaps somebody's been there, and perhaps you've seen some sort of documentation that award hasn't been ratified or it hasn't been enforced, that's going to be a factor in terms of how we view whether we want to actually fund that opportunity. But by and large, what you can say for state-owned entities is that they have deep pockets, typically speaking. So it may be more attractive to a certain degree than looking at contractors who you know very little about their solvency, because you can't get anything from the equivalent of Companies House in that regard. So it isn't a definite no. It really comes down to looking at each opportunity on its own merit, shall we say. What we also find is if you look at, for example, the list of 50 contractors across each sector, whether it's general contracting, infrastructure, power, and so forth, utilities, what you're generally going to see is most of these contractors are private companies. Very few of them are listed companies. There's only 2 listed companies on DFM. Some of them are branches of international organizations. And the amount of sheer construction projects that have been delivered and are currently being worked on across the UAE, Saudi, the GCC generally is such that you're going to find a huge amount of the opponents are not state-owned entities. And those which are state-owned entities, yeah, we look at them on a case-by-case basis. There's also the element of if there has been some sort of interference and you've got a bilateral investment treaty in place, or you can pursue the matter up to ICSID, you may have a second route to that anyhow. And as a litigation funder, we fund ICSID arbitrations, we fund bits, so we're pretty familiar with this space. It isn't something that is a deterrent off the mark.
Right, well, that's very good to hear. There are obviously other issues that arise with respect to third-party funding and arbitration proceedings specifically. Let me go to Lara and ask you, what is your view on questions of disclosure of or not of third-party funding arrangements in arbitration proceedings? Should a third-party funded party have the obligation to disclose that in the arbitration, and why?
This is a tricky one. As far as I know, there's no general rule requiring parties to disclose a third-party funding arrangement. Now, I believe that transparency is always a better option. Now, to what extent, that's the question. I think the trend today in arbitration in general is always favoring transparency. Sometimes the parties themselves, the claimant prefers to disclose voluntarily, to show it can be to prove that actually, it has a financial capacity to pursue arbitration. Sometimes the other party, so the defendant, would actually seek the disclosure of the terms of the third-party funding to kind of, on the basis that the third-party funding is a sign that the claimant actually is impecunious, and so on that basis it should provide security for costs to cover an adverse cost award. I think that the non-disclosure may lead to abuse of request or application for security for costs, for example, but also the systematic disclosure I don't think should be mandatory. I believe there should be transparency, so I'm more in favor of that, but it also we have to think of the fact that the non-disclosure may also kind of trigger some reactions from the other party, and I think that it's for the arbitrators in that case to assess whether the applications from defendants are abusive and based on a simple and founded equation of funding with impecuniosity, or if it's well justified.
Thank you very much, Lara. Well, that's such an interesting conversation. I have difficulty stopping, but I was just reminded that our allocated time frame is finishing in about 9 minutes. And since we're no longer in the physical meeting space and electronic space, I'm worried that we may be cut suddenly in 9 minutes. So let me just briefly, perhaps, to close on this before giving the floor to Alec for a concluding remark. Ask Joe, what is your reaction to this whole debate about transparency? Do you see the need for disclosure of third-party arrangements? I mean, have you been ordered to pay the costs of a winning respondent? I hope not for you, but this is typically the kind of situation where this arises.
Yeah, I mean, look, at whether you're funded or not is pretty much neither here nor there. Some parties choose funding out of choice, they don't need it. Other ones choose out of necessity. So if a claimant is going to make that, or if a respondent is going to make that application for security for costs, it would seem to me that the tribunal has to assess the application based on whether or not the claimant is impecunious or not on whether it is funded, because the two are not the same thing. I mean, put simply, if you went down to HSBC and asked for some capital to go and help you in your arbitration, what you're not going to expect is to actually see the loan agreement produced, and no arbitrator is going to ever entertain that. So I don't see security for costs in any different light. If there is evidence that the application succeed, it's got nothing to do with whether a party is funded or not. And that's something that the arbitrators can ultimately deal with. And I think that Lara hit the nail on the head in that aspect, that it really comes down to how the arbitrators view it and in those particular circumstances. And then one of the points that you mentioned was conflicts of interest. Again, it comes down to transparency. If an arbitrator is sitting on a panel where that party is funded and the arbitrator acts as counsel in another matter which is also funded by the same party, they've got to take a view in regards to whether that is a disclosable event. It possibly is. I think that's probably the most adult and mature way to deal with this.
Probably is in my view, but that's probably the arbitrator's problem. He or she needs to decide whether he or she needs to make that disclosure or not. Listen, we have one question which I see here from the audience, which some of the other questions have been addressed already, but there's one question I'm not sure if anyone will be able to properly handle, but let me try it with Joe. Is there any jurisdiction, to your knowledge, where third-party funding of arbitration cases is rejected? Maybe you know this since you are.
Well, I'm sitting in Dublin right now, and in Ireland, third-party funding still falls under the rules of champerty and maintenance, and there have been a Supreme Court case in that within the last 3 years. So there are certain jurisdictions. Ireland is a common law jurisdiction which prohibits the use of third-party funding. I believe it's the same in Nigeria. There has been a relaxation of the rules in places like Singapore and Hong Kong, and as Alex had mentioned, you have Abu Dhabi Global Markets and the DIFC, which is specifically addressed it in their legislation. So there are certain countries tend to be common law jurisdictions that haven't yet moved into the 21st century, shall we say, in regards to it.
It's both a concept that is popular in some common law jurisdictions and rendered illegal in some other common law jurisdictions. That's
yeah, it's illegal. It's still a crime to be involved in it in Ireland, but we would suspect that will change in other jurisdictions.
Well, then we promise we will keep quiet your profession in Ireland. So let me now, without further ado, give the floor to Alec, who will share with us some concluding remarks. Before I do that, I'd like to thank the panelists for their numerous and wonderful contributions. Thank you very much.
Thank you, everyone. I'd like to second that. So I see it's 6:25. I promise I won't keep you beyond the witching hour. I'll just start at the end and express my view that I think the fact of funding, but not the details, has to be and should be disclosed if for no in arbitrations, if for no other reasons, to ensure that none of the arbitrators have a conflict. And that applies to whatever sort of funding it is. There may be insurers running a case, in which case that needs to be disclosed. Wherever the money's coming from, it could create a conflict with one or more tribunal members. I think that funding will become more popular, and it is already progressing in the region. I think within quite a lot of private and public companies, there is both a growing sophistication and the realization you can use this for balance sheet improvement purposes, and it doesn't have to be because you're impecunious. Additionally, I think there's also funding for cash flow where parties don't have the money. I think in these post-pandemic times, a lot of companies are a bit short of cash, and I think there's anecdotal evidence that although there's been an increase in disputes, probably some disputes grinding to a halt as a result of non-payment of fees. Just as an overview of what's been talked about in terms of managing costs and limiting costs in disputes, I think as a summary of what we've heard, what I would take from it is that there needs to be a radical reappraisal in this region, both of the way in which contracts are drafted. So there was some discussion of risk allocation. There are far too many unfair contracts, to put it in lay terms, very heavily weighted in favour, usually of the employer. And as has been commented on, that can itself lead to disputes. We've heard from Alex that in his view, employers tend to put their heads in the sand. I think they tend to go into quicksand head first. And as we all know, it's very hard to extract people head first from quicksand. They just get deeper into it. But there seems to be a lack of recognition of that situation. And in the same way, there seems to be a reluctance on the part of contractors to get early advice. And indeed, quite often you see people putting their claims together during construction arbitrations when it's frankly far too late, and incurring a lot of costs in that process. There were also comments on the engineer, the role of the engineer or the contract administrator. To change that, we need a radical change in the form of contracts used in this part of the world, and frankly, I don't see that happening. Dispute boards, I think we also need a radical change to the way in which they operate. I've been on a number of standing dispute boards that have never been set up because the parties wanted to save the small amounts of money it would cost in paying the members of the dispute board to be on top of what was going on in the project, and then only calling it in when there's a real dispute, and the dispute board have no background, and then you get into that situation where what you're doing is a bit like, or can be a bit like, an arbitration. So great in theory, but in the region, frankly, a bit like mediation, it's not working. So I think there's a lot of work to do, and meanwhile, there will continue to be a lot of construction arbitrations. They will be, as the stats show, bigger usually than those in Europe, and they will take longer and be more expensive to resolve. So I'm sorry if that's a little bit pessimistic, but I do think that people in the industry need to wake up. And on that, time's up, and I'll finish. Thank you all.
Thank you, Alec. Habib, will you wrap up?
I must say this was a very informative webinar, and thanks to all the speakers and those who attended as well. Thanks to everybody for joining us today.
Thank you, everyone.
Thank you for joining us.
Thank you.
Thanks to everybody for joining us today.
Thanks, everyone. Good night.